Good afternoon, everybody, and welcome to today's webinar. Ness, I appreciate that. I don't get called an expert very often, but my gut says you were referring to Jeffrey and Michael, so I'll let that pass. Again, good afternoon, everybody. Welcome to episode 4 of Association Continuity in a COVID World. My name is Craig Vaughn. I'm the president of Castle. For those of you who don't know Castle, we specialize in the management of apartments, condominiums, and HOAs in Florida. We partner with approximately 300 associations through 7 offices throughout the state with 1,750 teammates. I'll be acting as your moderator this afternoon and playing the role of board member. Firstly, welcome back. Thank you for your leadership. Thank you for your thirst for information. We received over 500 registrations for the webinar this afternoon and somewhere around 300 great questions. I've incorporated as many of those questions into this afternoon's webinar as I could. You're free to continue to chat in questions like Marion has explained early, and I'll try and work those into the conversation as we go forward. The webinar participants today, just for your information, are approximately 35% from Palm Beach and Broward counties each, 15% from Miami-Dade, and the balance from other counties in the state. We are using the Zoom platform to conduct this webinar. We checked the how Zoom was performing before we got going here this afternoon, and it's performing fine, so we don't anticipate any problems. If we do have any issues, I would suggest that you just simply log on and log off, and we'll do the same if we have a challenge from our end. We have a new feature for those of you who maybe were on our previous episodes, and that is we are going to pose some questions to you as participants this afternoon. It's called the polling feature. Throughout the webinar, I'll tee up a couple of questions. You can answer live on your computer. When we can fit back the answers in, I'll go back and we'll pull those answers up and give you some particular information. I would encourage you to quickly answer the questions as they pop up because they will disappear. So I wanted to start, for those of you who are now on, with our first question. Ness, if you can, it's question number 5. And we just want to know what type of community you live in. So Nez, if you could post that, I'll move on, and then we will come back and revisit that group, that answer after. I want to welcome back Michael and Jeff. Before I ask them to introduce themselves, I did want to remind everyone that they are not intending to provide specific legal advice for your community or your association. For those questions, you should reach out to your specific counsel. Instead, we just really wanted to have a dialogue today, a continuing dialogue, if you will, regarding the reopening of amenities as we continue to come out of the COVID curve. So we're excited about that. Jeff, if I can, would you a quick introduction, and then Michael, and then we'll go down to the agenda.
Sure. Good morning, everybody. Jeffrey Rembaum with the law firm K. Bender Rembaum. We specialize in representing Florida's community associations all over the state, 19 lawyers who practice every day in this body of law. Our main office is in Pompano, where Michael is. We have an office in Tampa, and of course, where I'm located in Palm Beach Gardens. So much to talk about. I know that everybody out there is familiar with our law firm. We remain available to help everybody that reaches out to us. Michael?
Thanks, Jeff. Good afternoon, everybody. Pleasure to be back. Good to have everybody on. Hope you'll get a great program. Again, I'm sure you'll get a great program and more information to provide. Excuse me, let me just add that Jeff mentioned that half of our attorneys are board certified in the area of condominium plan development. I also have the pleasure of being a part of the task force that is assisting the governor with reopening the economic part of Florida. It's called Reset, something that was appointed last week, and I look forward to working with a great group of individuals throughout the state on that. We do also have locations by appointment in Miami-Dade as well, and we're happy to have a bunch of people listening down there. And we look forward to hearing from you, and hopefully when you leave after the next hour, you'll have a lot more information to take with you.
Excellent, guys. Well, thank you very much again for being here this afternoon. I wanted to just run through the agenda. What we wanted to cover today, we're going to cover the current legislative environment. we're going to have a robust discussion on the emergency powers of the board because there has been some controversy in our world, and there's rarely controversy in the HOA condo world. So we're very excited about that discussion. We want to look at, again, amenity reopenings. There's lots of questions about pools. We'll talk about that. Liability and risk mitigation. What's next? And then if we have time and there's specific questions that aren't answered, we'll try and get to those. So before I jump right into the current legislative environment, can we, Nez, have the results of who's listening to us today and what kind of communities they live in? Okay, so I don't know if everybody can see. So 63% of participants live in condos, 35% in HOAs, and 2% in cooperatives. So those are your fellow guests for the webinar this afternoon. Thanks, Ness. That's great news. That's great stuff. And that was easy, I trust, to do. So let's go into the current legislative environment, guys. We are still under the state of emergency order issued by the governor, which is currently set to expire on July 7th. This executive order that triggered emergency powers contained in the statutes that boards utilize largely to shut down amenities and restrict access to their communities. Of course, we're going to talk about that a little further in a second. On April 29th, the governor issued an executive order initiating phase 1 of the Safe Smart step-by-step plan for Florida's recovery. Palm Beach, Broward, Miami-Dade were initially excluded from that, but then were later included. And it was that set of executive orders which built the framework for us to start to open amenities again, which has now been going on for 3 weeks or so. Guys, yesterday the governor announced that the state could enter phase 2 of Florida's recovery program, further relaxing the rules for businesses like bowling alleys, bars, theaters, etc. Of course, they excluded Palm Beach, Broward, and Miami-Dade counties, given the propensity for infections there. Every county in the state, every municipality has different guidelines. So we would continue to advise our webinar participants that they must be mindful of the restrictions that impact their community and to continue to seek guidance of their attorney and other professionals as you flesh out your individual reopening program for your community. So our plan today is to build on our discussion from last week regarding the reopening of amenities. Most of the comments will be applicable to all amenities and all community types. But before we jump into the latest governor's order, I'd like to, Marinez, if I could, poll question number 6 and see our mix. Is your association a 55 or better community? Sometimes referred to as 55 and over. We changed the description here at Castle when I got to be 55 because I didn't really like the description, so we moved to 55 and better. But we'll pose that question and come back to you with the results of that question. So Jeff, anything in the governor's order yesterday that changes the playing field for community associations?
Excellent question. It does, in a manner of speaking, because of what's happening around the state. So let's take a look at some interesting statistics. Since yesterday, we have 1,419 new COVID cases in the state of Florida. 60,183 total, 2,691 deaths. Palm Beach County, 211 new cases, 6,688 total, with 376 deaths. By entering into phase 2 for the reopening, the rest of the state, excluding Palm Beach County, Miami, and Broward, their business operations are going to be further opening. And I think that where it affects our community associations is in those associations where the board of directors has made business decisions that they're uncomfortable entering the reopening pool, or not opening the pool to the extent some of the members would like, and the other amenities, as the rest of the state reopens, is going to make it a little bit more difficult and a little bit more pressure on those boards. And to those boards, because we've seen some questions already come in this morning on that issue, do your very best to educate your members on the local orders, not what the governor is doing up in Tallahassee for the rest of the state, but discuss the exact language of the Palm Beach County local order, the Broward County local order, and what the requirements are, which we'll be getting into later during our presentation. and the challenges that you as a board face because of the liability that's out there. Also, I do want to point out, because everybody keeps saying Miami-Dade, Broward, Palm Beach is excluded from phase 2, only to a degree. We start out being excluded, but upon making a petition, if you will, to the governor from either the county mayor or county administrator, then similar to how we got into phase 1 in Palm Beach County, accommodations can be made by the governor to allow those counties into phase 2.
Okay. Okay, well, so, but really that we, general guidance, of course, and then again, you'd cascade down to the local level. So I completely appreciate that. Let's move on to the emergency powers of the board, a big issue for us and a subject of lots of questions. So I previously stated that it was the executive order that triggered the emergency powers contained in the statutes, 718 and 720, that boards utilize to shut down amenities and restrict access to our community. There has been some recent discussion regarding the DPBR weighing in on this issue of emergency powers. So Michael, I'm going to ask you if you could please give us some history on this issue and where we currently stand.
Sure. My pleasure. And also it is in 719 for those 2% of our listeners and cooperatives. And Craig, I can't believe you're 55. Don't tell me that. Okay, so really, let me start with just clarifying what immediately was, at least delivered to us, myself and other attorneys in our firm, a misconception that was caused by the recent action taken by Secretary Beshears of the DBPR. The governor did not rescind his state of emergency order. The governor's order, as you mentioned at the top of the hour, has been extended until July 7th, 2020, at least as of today. The emergency order that was issued by the DBPR, and the purpose of which was intended to suspend the, quote, damage requirement that was set forth in the emergency powers section of 718, 719, and 720. That was in direct response to, there was some early debate around whether the COVID-19 virus constituted damage such that it triggered those statutory emergency powers. So the DBPR issued what they considered to be a guidance to say, hey, these emergency powers that the legislature included, I think it was 2008 and 718, 719, 720, they are triggered by this governor's state of emergency order. Last week, the DBPR then issued a new order rescinding their prior order effective June 1st of 2020. I'm not clear as to why they chose to issue that order. It has obviously led to confusion for many, notwithstanding it was issued. So while the initial order that they issued tried to assist in offering some much needed clarity on the question of the application of the emergency powers that were granted to boards during this state of emergency, there were questions raised by many practitioners in the state whether the initial order by the DBPR was even necessary, and even if they had the authority to issue such an order. At this point, regardless of that, as of June 1st, we still have the language in 718, 719, and 720, the emergency powers, which grants certain emergency powers to the boards of directors during a declared state of emergency by the governor. And we still have that declared state of emergency in effect, at least until January 7th of 2020. So what we no longer have as a result of this DBPR June 1st order is we no longer have clarification from the DBPR that the emergency powers in the statute are available for the state of emergency. But we do still have the state of emergency, and we have emergency powers in the statutes, and we have the state of emergency by the governor. So with that in mind, it's the opinion of our firm, and as far as I'm aware, many community association practitioners, although not all, there are some who maybe disagree, that the emergency powers that are described in the 718, 19, and 20 do apply to the COVID-19 pandemic, upon which the current state of emergency has been declared, regardless of that recent rescission by the DBPR emergency order. Although, and as Jeff is going to discuss a little further, and we'll get into more as we talk about liability risk mitigation, it is an unprecedented time. It's an unprecedented state of events, and you know, there's no way to say definitively if the board is, if a legal action is brought claiming, hey, you're overstepping your authority by enforcing these emergency powers, it would have to be decided in a court of law.
So thank you for your opinion, DPBR. I guess there's one issue that says they were never invited to the party anyway, right, because the governor had issued the executive order. Jeff, what do you think the risk is here? What are you telling your clients with respect to this, their exposure to liability, given this new declaration by the department?
I think that the department, when they first came out with their first order, when the DBPR came out and said that that particular language within the legislation doesn't apply, the limitation of emergency powers, a condominium association during a declared state of emergency being conditioned upon a response to damage caused by an event. That's the language that DBPR said, it doesn't exist. First question, who is the Department of Business Professional Regulation to temporarily rewrite a law that was passed by the legislature and approved by the governor of the state of Florida, absent very specific authority to do so? It was nice of them to try. I will certainly give them credit. I think their heart was in the right place to give community association boards the understanding they could rely on the emergency powers. I don't think it was ever necessary in the first place, as Michael alluded to. So when they came out and said, our prior order is no longer effective as of June 1st, but the governor's emergency order is still in play, then, as you suggest, that question of whether the emergency powers in the legislation can still be relied upon by the boards of directors is again right up, and everybody is having to deal with it. It's issue number one. Until a judge tells me otherwise, you bet. What is more important than the health and safety of the membership of the occupants living in a condominium, the members living in the homeowners association? There really isn't much more important than that. It's the most important thing I can think of, right? Our health, safety, welfare. And boards of directors have a fiduciary obligation to their membership. So I think it is smart to continue to rely on those powers, but each association is going to be different in that regard. The board of directors needs to have a certain comfort level there to continue to do so, and they should consult with their lawyer as to whether or not the lawyer is comfortable. Could there be liability? You know, we could walk out of our office and trip and fall. Things can happen. Can someone file a lawsuit? You didn't open the pool in time? I suppose they could, but what is the damage versus the damage of not closing or not taking proper CDC social distance precautions?
Right. Well, I think that's good. Guys, this is brand new Monday, so I'm sure over the next 2 weeks, we're gonna hear lots about this, and you're gonna have boards are gonna have lots of discussions with their attorneys. I think what consensus seems to be from who I've talked to is that exactly, Jeff, your position, and Michael, your position, which is there's still a state of emergency. That didn't change, and that's what the board's acted upon. July 7th is coming upon us pretty quickly. Our next webinar, episode 5, is going to be the 18th. So at that webinar, we are going to start to address what does it look like after the executive order has been lifted and the emergency powers. So to those listening, please tune in for that. And I'm sure we'll have more discussion on this particular issue with the department. Guys, I want to move on to a discussion on the reopening of amenities, a continued discussion. But before I do, let's look at the results of our question concerning what type of community our webinar participants are living in. Is your association a 55 and better community? So if you remember, there's 37% of the people lived in HOAs, and 32% of them are 55 and better. So the balance being not 55 and better communities. So that's interesting results, because I know there is a lot of angst in our 55 and better and all associations about the pools, and that's what we're going to jump to now. So before I get, one more, I want to poll the group again. If your community has Ness, poll question number 1. If your community has a pool, is it open? So let's see what the results are of that. And then I'm going to jump to a discussion about the pools. In episode 3, guys, we spoke about the importance of each community having a plan for the reopening of their amenities and having that a plan approved by their legal counsel. We spoke about a framework that can be used to draft a community plan, acknowledging that communities are subject to different regulations, physical plant limitations, different demographics, staffing, budgets, all kinds of things. Any plan has to comply with current regulations affecting the community, and that's why those are moving all the time, and that's why we're encouraging you to get with your attorney. and also the recommendations of the CDC, specifically with respect to social distancing, gathering, and cleanliness. We'd like to get an update on where we are from a regulation standpoint in Palm Beach, Broward, and Dade, specifically as they relate to the reopening of pools, clubhouses, gyms, and tennis courts. So let's start with pools, and Jeff, I'll start with you. Can you give us an update on the current guidelines regarding the opening of pools in the Palm Beach County market?
Absolutely. It comes from order number 2020-007, available on the Palm Beach County's homepage website. Social distancing guidelines need to continue to be followed along with the other CDC guidelines. Locker room and shower facilities remain closed. Restrooms may remain open, but they must be cleaned and disinfected regularly throughout the day. Soap and water and/or sanitizer and disinfected wipes must be provided. Pool deck seating and lounging must be restricted to ensure social distancing in accordance with CDC guidelines. Lots of questions this morning on can we remove the furniture from the pool deck, at least as to Palm Beach County. Michael, I'll let you address Broward, Miami-Dade, but as to Palm Beach County, I'm just fine if you want to remove the pool deck seating that is there and have residents bring their own, so long as the CDC guidelines are adhered to. Staff that is authorized to manage the pool needs to provide notice to the membership, and that notice can be provided either U.S. mail, electronically, meaning email, facsimile, and/or by posting a sign. If you really want to go all out, you can cover all three bases, but you need to do one of those, and the message, the signage must say all users of community pools shall abide by any and all social distancing guidelines, including but not limited to the CDC guidelines, and that said users of community pools bear the responsibility of such compliance and assume the full risk of utilizing the community pool. Now, there's also the compliance needs to be accomplished by any reasonable means, including but not limited to periodic spot checks, video, other electronic monitoring, and/or compliance hotlines to allow for reporting of violations that are thereafter promptly investigated. So we have a lot more leeway in how the monitoring of the pool can be accomplished. We know we have to provide signage. We know the restrooms can be opened and how they have to be cleaned, etc. Yes, absolutely. To those who have asked, what do we do if violations are reported and members are ignoring? The fiduciary obligation at that point, I think, of the board would be to close the amenity back down again and let the membership know what happened, and then say, we're going to reopen it again, but if this happens, we're gonna have to close it down again.
Jeff, is there any specific, like we've heard you can have 25% capacity, 50% capacity, are there any specific guidelines, or is the general, you could have as many people as you need, ensuring they maintain social distancing?
Social distancing. In Palm Beach County, you have to maintain the social distancing.
Okay, and you made a good...
Oh, another question we got in, Craig, is what about requiring members to wear face masks in the open areas? And I think if the board wants to adopt a rule requiring that, I think they can. It would be within their purview.
Good. We're going to talk about that a little more later. We're going to poll the audience as to what people are doing. I think the other thing you said that's important is you don't have to open my pool. At this point in time, I'm not required to open my pool, but I can. Is that correct?
That is correct.
And then, okay, well, that's great, guys. We had lots of questions on that. What about gyms or fitness centers, Jeff? And we're still in Palm Beach.
Well, we don't have specific guidance on the gyms and fitness centers, if you will, for as a carve out, if you will, for community associations. What we do have is attachment 4, revision 1, dealing with private parks, natural areas, and public parks. And there we find guidance regarding recreational buildings and gymnasiums may reopen to 50% capacity limitations. And once again, so long as CDC social distance guidelines.
I think that's kind of what the guidance that our associations that have opened their fitness centers are following, kind of the whole 50% occupancy thing. Clubhouses, kind of same rules, opening, maintain social distance.
Right. And we had a reader had to put in a question, can we require in the gymnasium individuals to wear the masks when they're not using the equipment? And again, I think the answer is yes.
Okay. And then what about tennis quickly? I can play doubles now and have lessons? Are those the rules in Palm Beach?
Yes, sir. We can play tennis again. You can have doubles, but you cannot congregate on the court or the sidelines. Locker room and shower facilities have to remain closed. Same rules for restrooms. They can be open. They have to be cleaned, disinfected regularly, provide soap and or hand sanitizer. Tennis instruction can be conducted on an individual basis. So no group instructions right now, individual basis, where strict social distancing is followed. And it is the responsibility of staff or management, once again, to ensure compliance with the Palm Beach County order.
Excellent. Okay, well, listen, that's great guidance and a great summary. Thank you very much. Michael, before we get to your comments on Broward and Miami-Dade, Ness, can we look at the answers to our poll? If your community has a pool, is it open? So for listeners, 60% have their pool open, 39% don't, and 1% don't have a pool, so you don't have these headaches. So that is good news. But that's why all the pool questions. Lots of people have pools, 60% open. I'm a little surprised that 39% are still completely shut down. I think that's very safe and probably speaks to some of the limitations, which we're going to talk about shortly. So, Michael, let's jump to you. Now we're in Broward County with pools. Anything different in pools, or can you give us a quick summary on the pool regulations?
Sure. What I'll do is, Craig, if you'd like, I'll go through Broward County. I'll go through the amenities in Broward County, and then I'll touch upon the amenities in Miami-Dade. One of the things that early on, there was an order. It wasn't an order. It was some kind of document that was put out where Palm Beach, Broward, Miami-Dade, all were going to work together and in conjunction. And so we all thought, okay, great. Everyone's going to come out and they'll have these guidelines that we can all understand and follow and be uniform. And it's not remotely the case. So Jeff just went over a great review of Palm Beach County. So let me just touch upon Broward first, and then I'll get to Miami-Dade a little bit. With regard to pools and pool decks in Broward, well, first of all, in Broward County, there is still the limitation on guests. It's a modified limitation now, but in Broward, the pool deck, tennis courts, gyms, community rooms, that's for residents only. Although Broward did modify their order as 20-13, which was, I believe, last week, where they extended it to allow family members if the board of directors has adopted that will allow that additional attendance. So it is not automatic. It is something that the community association can continue to limit to residents only. But in Broward, if the board determines, the board through its rulemaking authority determines they're going to extend access to the pool decks and the facilities to family members, gyms, communities, that is okay. Otherwise, it's residents only. So simple one, tennis courts. Tennis courts was extended to doubles play. So it could be singles or doubles play, social distancing, but residents only. So there is no lessons being given unless your lesson is being given by another resident. With pools and pool decks, residents only and extended to family members, like I mentioned, if the board so desires. You have your 6-foot social distancing, and I think we all understand the CDC guidelines with the social distancing is mandated everywhere. The sanitizing and the efforts to make sure of sanitizing and cleaning, those should be incorporated everywhere. There are certain specific requirements in Broward with regard to the pools and the pool decks. Capacity is no greater than 50%. And then as we mentioned last time, I'm going to go over it again. This is still an either or in Broward. You either supervise, you have to have use of the pool and pool deck supervised by a sufficient number of employees or others designated during pool's open hours that ensure compliance with the requirements of the order and sanitize the pool chairs, rails, gates, table showers, and any other equipment on a regular basis, or remove all the furnishings from the pool deck. So in Broward specifically, they've said, hey, if you want to remove all furnishings from the pool deck, go ahead and do that. And that would presumably then eliminate your need to do certain supervision. But I would emphasize, and I will tell everyone listening, if you're opening your pools in Broward County and removing all furnishings, I still recommend that you're doing your standard maintenance. And at a minimum, and certainly an accelerated level of maintenance where you continue to sanitize high-touch areas, and supervise to ensure social distancing and that your capacity remains at no greater than 50%, and that it's only residents or their family members if you've extended to family members, because you do continue to have the obligation and the potential liability for ensuring these requirements are all being met. With regard to gyms and community rooms in Broward County, again, no guests, residents only, other except family members can be, if they're not non-resident family members, if the board has extended that authority. If not, then it's residents only, 50% max capacity. Social distancing is required, although again, it does point out if you live in the same household, you don't have to social distance. In your fitness rooms, machines, equipments, those need to be 6 feet apart minimum. In the community rooms, tables need to be 6 feet apart. There's no gathering, no multiplayer games unless you're all in the same household. Hand sanitizer available, disinfectant wipes available. You need to continually, if you have facility bathrooms open, make sure that they are being regularly sanitized and that you have the soap and water. Inside hot tubs, saunas, steam room, showers, those all remain closed in Broward County.
Michael, are you going to jump to date? Before you get to date, I just wanted to clarify a couple of things.
Go ahead.
We have a couple of questions. So, and Jeff, for you, we're only required to monitor the pool in Broward if we continue to have furniture there?
Well, no. What I said is the monitoring requirement in the either or seems to indicate, hey, if you remove the furnishings, well, then you don't have to obviously clean the furnishings. But the orders still require that you meet these guidelines. And so you still need capacity no greater than 50%. You still need social distancing, and you're not gathering in large groups. And if that is going on, then that is a violation of the order. So notwithstanding the way this is written, my advice is that my opinion is that you need to be ensuring that these requirements are being met. There's no mandate as there is in Palm Beach to monitor in that regard. But if you're not keeping tabs on that in some way, and there are violations, then that is a risk that you are taking, because you do have the requirement to make sure the order is being followed. That is limited to residents only unless you've extended to family members. You're not having outside guests there. All of that is something that so if you're going to open your pools, and Broward actually did something which I didn't see in Palm Beach or Dade, at least I don't recall, but they actually have specific language above that, their attachment on pools and pool decks, which I think applies to all amenities, and they say, and I'm paraphrasing, you don't need to open.
Right.
If you are not in a position to open, or you don't feel that you're able to meet these requirements, then you need not open at this time. And that's directly in the order.
And then, guys, just to circle back for a second, Michael, there's a bunch of questions on restrooms specifically. Do they have to be open if the pool is open? Let's start, Michael, with you, and then Jeff, I do want to pop up to Palm Beach, but Michael.
Yeah, well, I think the answer is the same. I think in all locations. I think that there are Department of Health requirements, and I think you have to check with your counties and municipalities. I believe if you have your pool facility open, you may be required to have your restrooms open, and you want to make sure of that. Get with your management team and contact the local authorities if you're unsure. But I believe that if the pool is open, those may need to be open as required by the Department of Health and local orders, local requirements, building code requirements, things of that nature. Again, having them open, if you don't have them open, then what you do, then the risk is that if someone does a spot check or someone self-reports, then you have exposure. Then I don't know how aggressive they're being. If they're just going to come out and say, listen, your pool's open, open the bathroom, or to close the pool. If it's required, I don't know how aggressive they're going to be. If you are opening them, and if they need to be open, you should be opening them, then you must do what they call, quote, regular. And I think that means you need to frequently be doing your sanitizing, cleaning off the high touch areas. If there's showers inside those bathrooms, they should remain closed.
Yeah, so you can open if we have a restroom with a shower, you don't close it just because it has a shower. You just, you make sure the shower is shut down. Jeff,
correct.
With respect to restrooms, any specific items?
I would basically like to take what Michael said and just repeat it.
Okay. Well,
Can we just rewind for a few moments and we'll come back in? But I was asked I'm typing as many answers as I can to some of the readers that are putting questions in. And somebody asked, how often is regular cleaning? What is like a minimum? And I would suggest to those that are listening that at least hourly, the bathroom should be checked.
Yeah, we have recommended guidelines for the time. We're going to talk about cleaning But if our webinar participants email info@castlegroup.com, we can send you out kind of our recommended cleaning schedule for amenities to comply with the CDC guidelines. We're going to touch on that again.
Greg?
Yeah.
Do you have the orders? I know the kbrlegal.com website, we are posting the orders as they come in. Some readers are asking me how they can find them. They can go to their local county's website. They can go to our website to find these orders. Can they go to the Castle website and find the orders as well?
They can. They can just hit, there's a COVID-19 tab on our website.
There you go.
Right, and as just said, at kbrlegal.com, we have a section, COVID-19 section that was added to the website back in March, and we continually update that. So there's another resource for everybody. Let me jump into Miami-Dade, Craig.
Please, Michael. Yeah.
Okay, and Miami-Dade has been, we seem like the state opens, then except for Palm Beach, Broward, and Miami-Dade, and then Palm Beach opens, and then Broward, and then Miami-Dade. Generally in that order. And Miami-Dade has done things a little bit differently, whereas they have created a 180-page booklet, which is very, very good, a lot of detail, and it is up on our website if anyone in Miami-Dade would like access to it. Again, you could probably Google it very easily and get it. It does reference tennis courts, singles only, as far as I can see from the order, is what's allowed there. Gyms remain closed as of June 1st. So with gyms, as far as I'm aware, gyms in the community associations are still closed in Miami-Dade. Tennis courts, singles only. With regard to swimming pools, in that booklet, it's page 66 of the booklet. It's actually of the handbook, and the order has 6 pages, so it's 72 of the attached order. It goes over protocols for swimming pools, and it's not specifically addressed to community associations, it's all pools, and they have bold language, and then they have a non-bolded language. The bold language is mandated, and then the other language is not bolded, is otherwise recommended by the order. And just to go through some of these, with regard to protocols serving community pools, pools at condominiums included, apartments and other residential complexes, all included. They break it down 3 ways. Workforce and visitor protections. You have to situate hand sanitizing stations and or disinfectant wipes around the pool deck area and in public restrooms. You have to establish a one-way flow into and out of the pool deck if there's a single entry exit point, complemented by directional tape and personnel to monitor. That's bolded. That's a mandate. Again, it does say if there's a single entry exit point. You have to, if they've been removed, put your life-saving equipment back on the pool deck in easily seen, accessible spot. Deep clean prior to open, which is the pool furniture, gate latches, handrails, life-saving equipment. Those are the mandates. There are a couple other items that I'm not going to read that are recommended, which you can get from the order. Business process. Place clear markings on the floors and other areas to ensure guests follow social distancing guidelines and spacing, including in the bathrooms. Remove chairs and lounge chairs on the pool deck to achieve appropriate, which is to say at least 6 feet spacing between guests. If there are bins, place them outside of the 4 feet wet deck. For pool bars, remove bar stools and chairs, mark spacing distances, and place barriers between guests and employees to ensure 6-foot distancing. Enable all entry gates to pool area and doors to self-close and self-latch. Ensure vacuum port covers are installed. Remove any solar blankets from the pool. Check handrails, ladders, diving boards to ensure they're securely installed. Ensure the pool recirculation pump is set to run at least 3 hours before the pool opens to 3 hours after it closed, 24 hours a day. Public health interventions. Provide training to employees on the personal protective equipment and how to properly dispose them, how to detect symptoms of the virus, procedures to follow in case an infection is confirmed. Place signage in several high visibility areas around the pool, noting the social distancing policies that are in effect for all persons on the pool deck and in the pool. Use visual or infographics educational material provided by CDC and DOH on this issue. Ensure pool rule signs are posted and easily visible from all areas of the pool. Clean or backwash filters to remove any buildup of dirt or debris. Ensure anti-entrapment devices are installed and working properly. So, as you can see, they have put a conglomerate of different things, whereas Palm Beach and Broward seem to be very specifically geared toward the community association pool situations. Miami-Dade has sort of clumped this all together, and obviously there are things in here that are more pertinent to the hotel or larger public pool, But that said, this is all encompassing. So to the extent, and these things I read are all mandates. So to the extent that you are looking to open your pool in Miami-Dade County, I urge you to get with your legal counsel, get with your management team, discuss what your do's and don'ts are, and whether you can meet these guidelines. And again, if you cannot, or you are not prepared, feel comfortable that you can do so sufficiently and document it, that you are doing what you need to do, then I recommend you do not open yet. You take a step back. That's it. I know everybody wants to open, so then get with your business leaders, get with your team, and put in place your requirements to meet these guidelines of this order so that you don't expose yourselves to a claim that may not be covered by your policy, which we'll get to a little bit later.
Well, all I'll say to those participants from Dade County, I'm sorry. 186
Yes, I'm sorry. Don't shoot the messenger on that.
bedtime reading, it'll put you to sleep. So, but in all fairness, get with your association council. That is a vast set of guidelines and mandates you have to follow. Guys, we talked a little bit earlier about masks, and I wanted to ask our community, and Ness, poll question number 4, is your community requiring facial coverage masks in common areas? So let's get a feel from our listeners as to what's going on, and we'll come back and revisit that in a few minutes. Jeff, I wanted to jump to you if I could. Can associations mandate that masks be worn in common areas?
Before I address that, and I will, I've just been very, very busy in the background trying to answer some questions. A reader has just given us some good information regarding the restrooms, and Florida Administrative Code 64-9E provides guidance as to whether the swimming pool can be opened if the bathroom is closed, which I suspect the answer will be no. But that's where everybody can go. I know when we're done here, I'll be going to take a look at that administrative code provision 64-9E. As to your question, can the board of directors adopt a rule requiring members to wear face masks when in the presence of others, such as in the condominium common element hallway, in the HOA tot lot, and such areas? Yes, I think they're well within their rights to be able to do so. Another reader asked a question, well, if we do pass such a rule and it's not followed, can we fine a member for that? And I think if you follow Florida statutes and the board properly adopts a fine, the member is then provided the required letter that the fining committee will be meeting not sooner than 14 days from the date of that letter, provide the member the opportunity to appear. The fining committee actually meets and the fining committee actually agrees and doesn't modify what the board did, then I think you're probably in a positive position at that point regarding the fining or suspending of use rights, whatever the penalty the board might have on its mind. But I do think that you'd be well within your rights to require it, and I do think it can be enforced.
Yeah, Craig, I'd like to just add, if I could, just real quick on that. And I agree. Everything Jeff said, certainly from a legal standpoint, is 100% accurate. I do think, though, that you do need to, the other considerations you have in here are the ability to uniformly enforce such a requirement. And whether with everything that's ongoing in our world today, if that is a battle that you want to take up, and I'm not offering yes or no. I just think there is the other considerations. I would like to think that if you're encouraging and urging your residents to, be more selfless and think of others in that regard, that everyone will generally cooperate with. And maybe so you might look at it as opposed to a mandate, a more like that Miami-Dade said, these are mandated, these are strong recommendations. So we strongly recommend that everybody be wearing masks while in the elevators or in common areas, etc. When you leave your unit to your building, if in those types of facilities, it's more impactful in a condominium or cooperative. So
Okay.
I do think that keep in mind. But certainly, if you do put something in place and people aren't following it, they do expose themselves to a rules violation like any other rule.
And I think also, in addition to that, it really should depend on the makeup of the community itself. For example, a condominium that is in the downtown area made up of individuals between ages 20 and 40 as compared against a condominium with an elderly population and the average age is 70. Clearly, there are different protocols and procedures needed to protect the elderly because of the way COVID-19 affects the elderly so much more so than it does the younger population. So those need to be taken into account too.
Okay, guys, Ness, let's go back to our poll question and see whether our communities are requiring facial coverage in common areas.
Wow.
That's a lot higher than I thought.
Yeah, a lot higher on the no side.
It's almost a split though.
Yep, very interesting. So 54% are not requiring masks and 46% are. Interesting. I just want to quickly touch on, I want to get to the other items, but I do want to touch on the CDC guidelines for cleanliness. I mentioned them a minute ago. You know, every order basically says you can open your amenities subject to the CDC guidelines for gathering, social distancing, and cleanliness. With respect to cleanliness, there is a document, the CDC has issued a document setting out its guidance. It's called Cleaning and Disinfecting Public Spaces, Workplaces, Businesses, Schools, and Homes. These guidelines call for routine cleaning. Now, what does that mean, right? That's the question. Routine cleaning and disinfecting of frequently touched surfaces with EPA-approved products effective against COVID-19. And there's a long list in the guidelines. I would read it right after you read the 189-page Miami-Dade spec on opening your amenities in Miami-Dade. But I will tell you, and I mentioned it before, we do at Castle, we recommend it to our communities, specific timing for how often you have to clean and what to use. If you, again, email us at info@castlegroup.com, info@castlegroup.com, we'll get you that data. You know, finally, just to close off on the opening the amenities, you know, it appears that some associations continue to close all their amenities. That is well within their power, we talked about. You know, and that a lot of questions came in. I have a few people in my community are complaining, so I would suggest to board members, you're always going to have a few people complaining. If you think you're any different than any other association, you're not. So, you know, with the consent of your board at properly constituted meetings, adopt rules, get your lawyer's advice with respect to opening and closing.
Craig?
Yes.
There was a question you asked at the beginning of our time together. How does the governor's new order affect community associations? And it didn't occur to me until you just made a comment, but it actually does. And here's how and why. CDC guidelines, right now, if members are not in your same household, then how many people can meet in a group? What's the maximum?
Right.
10.
Right.
All right. Subject to the 6-foot CDC guidelines. So no more than 10 people, 6 feet apart each, meeting as a group on a driveway. Phase 2 reopening plan from the governor changes that to 50.
Oh, wow.
So from 10 people to 50 people. So that is something that will affect.
So that'll affect the pools. How many people can be on the pool?
Right, exactly.
Wow.
Yep. So there is an implication there.
Yeah, good.
Although you still have, at least in Broward, you have the limitation on the maximum no more than 50%. I mean, that's what I'm saying. You have
Right,
all these
exactly.
you have all these different things going on. You got to piece them all together and figure out your
Right.
math.
Yeah, it's a puzzle. It's a puzzle.
I understood there'd be no math.
Yeah.
Because the county orders can be more restrictive than the governor's orders. So then even if the governor relaxes it to 50 in phase 2, the local orders could still keep it restricted.
Yeah,
That's an excellent point, Craig. We should reiterate. That's an excellent.
Be more restrictive, right?
Yes, that's an excellent point. Not only can the counties can be more restrictive than the state, the municipalities, if they want to be more restrictive, can be more restrictive, and the associations can be more restrictive if they so choose. You cannot be less, but you can be more.
Right. Okay, guys.
So less is more.
That's great dialogue, and there's lots of stuff. You can find the handbook references, all that stuff on either of our websites. So I'll direct anybody who's asking questions there. I want to move on to non-essential visitors. Again, under the emergency powers that the board discussed earlier, the board was able to adopt rules limiting access to the community. In most cases, associations adopted rules to limit any non-essential visitors, friends, family, realtors, contractors, housekeepers, etc. I'd like to ask one more question to our participants, and Ness, it's poll question number 3. Are you still restricting guests and other non-essential visitors in your community? And then
Very curious to see the results of that.
I am too, and I will ask you, and Jeff, I'll start with you. What are you advising your clients with respect to relaxing rules at this point?
I'm advising them it's a case-by-case basis, and it really depends on what's happening on the ground. Every morning I wake up and I get a report on the new COVID-19 cases happening in the state of Florida, and more specifically dialing into Palm Beach County. And it just seems to me that until those numbers start going down, I don't see how anybody starts relaxing off of our present local orders until we start seeing COVID-19 numbers go down, not up. But that's really a business decision that each board will have to make. It's rather scary to me what's happening in some areas of our population. I was invited into a Facebook group that is, it's this Facebook group for the reopening of Florida. And it's mainly business owners, but there's a lot of conversation about the face masks and the social distancing. And it's surprising to me just how many people don't care about their neighbors, their friends, their family members, because there are all these comments about why they're not wearing masks and why they're not going to adhere to social distancing and et cetera, et cetera, et cetera. I even saw one article from somebody where they were accusing the governor of keeping Palm Beach, Miami-Dade, Broward counties in phase 1 because they're blue instead of red. It's just amazing what's happening in the populace. But getting back to the primary question, absolutely, if the board wants to continue with its requirements right now for reopening and limiting guests and limiting contractors, at this point, considering we're still in phase 1 and we're still having to deal with the increase in COVID numbers, I think they're well justified. Michael, what do you think?
Oh, yeah, look, I agree. And it, the next subject, I know we wanted to touch upon liability and risk management, and we're running short on time, but I think that, if I may, Craig, I want to just sort of piggyback a little bit on that in my answer, because I agree with what Jeff is saying. I don't think there's a change in what we've talked about with regard to non-essential visitors, in that you have the same concerns exist. That's, and so you're doing it's a risk assessment. It's a matter of what you feel you can comfortably deal with and address versus, whether you want to risk someone challenging you for not allowing someone in. And in that regard, I think that, as I've had conversations with a few clients where, as things are slowly reopening, they are looking to do the same. For example, with realtors, and again, we're talking non-essential, and Craig pointed out, it's non-essential. Remember, guys, we're not talking essential, we're talking non-essential. So, and people may differ, reasonable people can differ on what's non-essential, but I know one of the examples is like realtors. And so I have a couple of communities that told me, well, they're going to start allowing a realtor in, but it's limited to a realtor and no more than 2 people who are coming. It's not like open house, it's no more than 2 people. Coming to see with the realtor. They're all wearing, they're all masked. They're all, they're escorted in. They go up to the unit. They don't explore the common element areas. It happens to be condominiums, and they come back out. And that's a business decision, but it's also got to be guided and tailored and done appropriately. And I have other communities who are not yet ready to open. That's why I'm interested to see the results there. I don't think that I don't think the discussion has changed very much with regard to risk management and how you're handling it.
Okay, Nez, can you show us the results of our poll question? Are you still restricting guests and other non-essentials? Wow. 60% are no longer restricting non-essential visitors, and 40% continue to. That's another. My eyes are getting opened a little bit today. So these are interesting results, guys. Any quick comments? Because I do want to touch on a couple of the.
Very quick. Yeah, very quick. I think that is very interesting. What we don't know, and obviously it's not made for a simple poll that we're doing right now, but of those 60% who are no longer restricting guests or other non-essential visitors, do they have what limitations, if any, do they have still though? I can't imagine it just doors wide open like prior to, but we'd have to get into the specifics.
Fair comment. We have a couple more minutes. I want to jump on to liability and risk mitigation. I want to address a specific issue that we've been asked about with respect to insurance. There's a lot of discussion that there seems to be a general consensus that claims for damages related to COVID-19 will not be covered by virtue of exclusions in most insurance policies related to virus. There's also been a lot of discussion regarding legal defense insurance policies. And Michael, if you can you kind of give us an outline of what those policies do and don't cover, and maybe your guidance?
Yeah, sure. I'll in the interest of time, and I will definitely keep it brief, but I think that when you said there's a general consensus, claims related for damages related to COVID-19 will not be covered, I think that is something that is fairly well accepted. I want to say this at the top of this conversation is everyone listening, board members, managers, you should be communicating with your insurance agents and getting with your carriers and getting written documentation from them as to what coverages you have, what coverages you don't have, and then discuss with them what coverages might be available to offer further protections. So D&O coverage, and again, I'm speaking from someone who has some information, but I'm not an insurance expert, and that's why I defer you to your agents. But D&O coverages, directors and officers coverages, are not going to cover physical harm or emotional distress. So someone claiming they've become ill from COVID, or they have family members become ill, those I believe are going to be outside your D&O. You look at the general liability policy, and the likelihood is there are exclusions for this type of illness or cause. And that would leave the association unprotected, and that's where Craig, you asked about legal defense coverage. It's a gap coverage, and briefly, what my understanding of a legal defense coverage essentially is that if you don't have any other coverage, your D&O says no, your general liability says it's excluded, then legal defense will step in and will offer a defense coverage, basically the cost of defending any claim, whether the claim has merit or not. It has to be defended, at least initially. And a legal defense coverage will step in and will offer defense. It's not going to pay out any settlement. It's not going to pay out a judgment if it gets that far, but it is something that's available to address the cost of defense. What you need to confirm or get with your insurance agents and confirm is with the policies, again, there might be different levels of premiums, although I've been recently told there aren't that many different variations. I was told initially if you pay more, you could choose your own attorney. Of late, I've been told that's not the case, that the carriers do have their pool of attorneys, and so you'd have to double check on that. And I also was told, at least I believe I was told, that that may be a policy that does not have a deductible. So you want to get that information as well. And you definitely want to look, if you don't have a legal defense policy, I would contact that's one thing, put on your to-do list for today or tomorrow, contact your insurance agent, discuss with them what your options are. And I think that's a good idea to look for that.
Excellent, excellent, Michael. Thank you very much, guys. We're winding down. Jeff, I wanted if you could just clarify quickly. We talked about the governor's order making gatherings in excess of 50 people a violation, no longer 10. But the requirement is still to maintain social distancing, right? The recommendation is still to maintain social distancing 6 feet from non-family members. Is that correct?
That is correct. That is correct. Also, off subject, I just received another post from a reader. The administrative code provision is 64E9. I believe it was reported as 9E before, but it's 64E9, dealing with the requirement of restrooms and swimming pools. So thank you, Mr. Miller, for that.
Yeah, I've been looking at it.
I don't look at any of that stuff, so that's perfect.
And I think it's basically what I think it's saying is pools will need to be opened.
That's why we.
That's my very quick look.
Guys.
You mean restrooms need to be open, Mike?
Yes, if the pool's open, the restroom needs to be open. But that's a very quick read. Thank you to the reader who said us that.
Guys, thank you very much again. It's amazing how quickly an hour goes. I know, right? Want to remind everybody we will be back for episode 5 on the 18th, where we'll get to more questions. The playing field will change again significantly between now and then. So please join us. At that point, we're also going to address the HEROES Act, which is some legislation that can negatively affect associations. So we'll get a little update on that.
Right.
I want Michael and Jeff to thank you again for your time this afternoon.
My pleasure, Craig. If I think it's okay if we go a minute over, because I think it's very important. We've been talking about people changing and modifying their policies, and a point that we had discussed yesterday that you made, which I think is important to reiterate to board members. If you're looking at adopting, modifying or policies or adopting policies, do remember that the requirement to do so at open board meetings, posting notices, that hasn't gone away. So do follow the proper protocol, get with your counsel and get confirmed guidance that you're doing these things the right way. That avoids that type of challenge.
Well, good. Thanks, guys. Participants,
good advice.
Thank you very much for your time, and everybody stay healthy, and we'll circle back in another couple of weeks. So good luck.
Thanks again,
Thank you
Craig.
so much, and thank you to Castle.
Take care. My pleasure.
Be well, everyone.
Bye-bye.